Hi, I'm estate planning attorney Mike Smith with Smith Barid LLC and one half of the Estate Planning Guys. Today I want to talk with you about how to set up a proper estate plan for your family using something called a living trust. It's what I refer to as the ultimate gift. Now, a lot of people that you might talk to, attorneys, people that you know, things you might read on the internet, will talk to you about estate planning with a will. And while a will is an important piece of any estate plan, there are a couple of issues with wills that people may not know about. And living trusts neatly solve those issues. So let's talk about what those issues are. The first one is what I refer to as living probate. And what that means is that if you become incapacitated during your lifetime, so for example, if you develop dementia or you have a stroke and you can't manage your own affairs, your family may be forced to file a petition with the probate court to be appointed as your conservator. The conservator is someone who can take care of the assets in your estate, and they're monitored by the court. They have to meet certain requirements in order to be able to do that, but then they're responsible for making sure that your bills get paid, that investments are made properly, etc. And having that sort of oversight of your estate can be very cumbersome. It takes a bunch of time to get it set up in the first place, and then the ongoing maintenance of that conservatorship is burdensome for a family member who might not be charging any fees, or if there's a professional involved, it can be quite expensive to have a conservatorship. So the first thing that a living trust does is it helps us avoid that living probate. With a properly set up and funded living trust, we don't need to go through the probate court to get permission for anyone to take control of the assets. The trustee that you've named will step in and take over if you become incapacitated without having to go through that court process. The second big issue with planning with a will is that when you die, your family will be forced to go through a court proceeding called probate. This is filed in the probate court. It is a public filing. It's public court. So anybody that wants to can go to the court and read through the files, or as has become very common nowadays, many of these courts are online. And so people can search the information in the probate court to find interesting estates and find people that they might want to prey upon. The other thing about probate is that it can be especially time consuming. So with the simple estates with no disputes at all, it can be resolved typically fairly quickly, but it really depends on where you live and the judge in your particular jurisdiction. So in some places, it may take 30 to 45 days to have someone appointed as the executor of the estate. In other places, same state, same rules, but with a different court, it could take 6 to 12 months to have someone even appointed as the executor. And that's before they can even start doing the job. That just is the court saying, this is the person who's going to be the executor of the estate, the official in charge of the estate, and giving them the power to manage the assets in the estate. If there's a dispute over the estate, then all those time frames go out the window. Then it can be extremely time consuming if there's a dispute at all. Imagine what you're doing when you file that petition in probate court. Everyone has to be notified about it. So anyone who is what's called an heir at law of your estate is notified about the filing of the petition in probate court, and they're sent a copy of the will. So it could be someone that you intentionally left out of your will has to be notified about the will, and then they might become upset and they could file what's called a caveat, a contest to the will in probate court. And I had a client recently who passed away, and some of her family members felt she intentionally left them out, but they felt like they should have gotten something from her estate. So when we filed the petition in probate court, lo and behold, they filed caveats. And that case is now drug on for several years. So if there's a dispute in probate court, it can turn into a very lengthy process. Additionally, if you own property in multiple states, then your family will be forced to file probates in each of the states where you own property. So for example, if you had a mountain home in North Carolina and you had a vacation home in Florida and your residence maybe in Georgia, in Atlanta or Savannah, then when you pass away, your family will have to file a probate in Georgia as well as in North Carolina where you had your mountain home, and in Florida where you had your beach vacation home. But there will be a probate in each of those places with the typical fees that the court charges, as well as attorney's fees for attorneys to represent your family in each of those states. Probate lastly can be expensive. It really depends on the complexity of the estate as to what the expenses are. Some attorneys charge a percentage of the estate. Sometimes they're flat fees, sometimes they bill hourly. It depends on the attorney and the jurisdiction, but it can can be a very expensive process. So a living trust avoids all of these issues. A living trust is essentially a bucket into which you place your assets, and as long as you are alive and you're competent, you're holding the handle to the bucket. That means that you're making all the decisions about what goes into the trust, what comes out of the trust, how it's invested. Everything that you do now with respect to your assets, you do for the trust. You're called the trustee, but that just means that you're responsible for managing those assets just like you do right now. Now, because the assets are in this bucket, if you become incapacitated, the person that you've chosen to take over and named in your trust as the successor trustee will simply take the handle of the bucket from you, and they will now manage those trust assets for your benefit, just as you did when you were capable of doing that. So it avoids the problem of having to go to the probate court and have a conservator appointed to manage your assets for you. The trust holds all those assets in the bucket. You just hand the bucket to the next person that you've named, and they take care of managing those assets for you. Likewise, when you pass away, we can avoid the death probate that occurs when you die. We don't need to go to probate court because all of the assets are in this bucket, the trust bucket. And the person that you've chosen, the successor trustee, just takes over the bucket, follows the instructions that you've put in the trust about how you wish for things to be distributed, and distributes them out to the beneficiaries that you've named, all without going through the probate court process. Additionally, there's nothing filed in the courthouse. There's no public filing of the assets that are in your estate, and it makes it more difficult for creditors, frankly, to find out about what's in your estate and who your beneficiaries are. The other thing that's nice about a living trust is that you can control the distributions out of the trust. So what do I mean by that? If you think about a tube of toothpaste and you think about every night when you go to brush your teeth, you got two options. My wife and I argue about this all the time. One is you can squeeze the tube from the middle and just squeeze out all the toothpaste. The other option is you can squeeze just a little bit from the bottom as you need it, just a little bit at a time. Now, if you've squeezed all that toothpaste out of the tube, you're gonna have a really difficult time getting it back in the tube. But if you squeeze just a little bit at a time, that toothpaste tube is gonna last you for a long time. And I think of a trust and the distributions out of a trust in the same way as that tube of toothpaste. So if I want to leave my assets to my children, I've got two options. One is I can do an outright distribution, so I can squeeze all the toothpaste out of the tube, and that might be okay if I trust that they can manage the assets, if I know that I'm confident of their choices in marriage, I believe that there are going to be no issues with divorce or anything like that, or creditors. That might be a great solution. The other option would be that I can control the amount that can be squeezed out of the trust over time. And that allows me to provide a backstop for my children that will last them hopefully over their lifetimes, but certainly for a much longer time than if we squeeze all the toothpaste out of the tube at once. So with a living trust, we can set up those distributions however you want. We can say, well, if Johnny works every year, then he'll get a distribution from the trust. We can do things like say, Johnny can only have distributions for his health, education, maintenance, or support. Or perhaps Johnny can have a percentage every year until the trust is fully exhausted. Your imagination will really be the limit for that. You can do anything that you want to do in terms of the trust distributions. But the great thing about it is that with a living trust, we can set up however you want. Now, the other great thing to know about a living trust is that you can change it anytime you want to. So if we set up a living trust for you today and you decide that you want to split things evenly among your three children and give it to them outright, but then a few years down the road, there's an issue and one of your children gets divorced or has some sort of creditor concern, and you want to protect assets that you leave for them, then what you might do is say, well, the first two kids, I'm going to give them their distributions outright. So they'll receive a distribution from the trust completely outright. We're going to squeeze the toothpaste out of the tube. And the third beneficiary, because he's had these issues and we want to protect the assets for him. It's not that we don't trust him. We just want to protect the assets for him. In his case, we're going to keep the assets in trust and we're going to allow him to squeeze out a little bit as he needs it, but we're not going to squeeze all the toothpaste out of the tube. So you can set things up and then you can change them as often as you want to. That's a great thing about a trust. That's why we call it a revocable living trust. trust. Now, the trust is the centerpiece of this estate plan that I refer to as the ultimate gift, but there's some other documents that are really important to have as well. The first one is what's called a power of attorney. A power of attorney is a document where you name an agent, called an attorney in fact, who can take care of financial or other personal matters for you. Nothing to do with healthcare, but things like paying your bills, making sure your tax returns get filed, etc. The power of attorney is a backup document when you have a living trust, because what you want to do is make sure that you put all of your assets into the bucket. And if you have, then the trustee will be able to control those assets. But the power of attorney is there in case we've left something out of the bucket. So in case you forgot about something or you've acquired a new asset and haven't had a chance to put it into the bucket. And it also covers things besides just the financial. So the power of attorney is really important in a living trust plan. The next thing we want to think about is we're taking care of the financial assets with the living trust. But another thing that's really important is your health care. And who's going to make healthcare decisions for you if you're unable to do so? And there's a couple of documents that we use to address that. The first one is what's called an advance directive for healthcare. You may have heard this type of document referred to as a living will before. It's the same thing. What this document allows you to do is to name someone who can serve as your healthcare agent and make medical decisions for you if you're unable to. So for example, if you were in a coma and someone needed to make decisions about your treatment, your healthcare agent would be able to do that. The document also allows you to make a statement about your wishes with respect to end-of-life treatment. So do you want a ventilator? Do you not want a ventilator? Do you want CPR? Are there other types of treatments that you would like to have or have withheld? Those are things that you can outline on this advance directive for healthcare. It's a super important document. You may remember the Terry Schiavo case years ago where that person's family got into a dispute about her wishes and what they were. She had never put her wishes down in a living will or an advance directive. And that family spent 10 years fighting over what she would want to happen. And the case went to the Supreme Court and back to Florida and back to the Supreme Court. Very complicated, very expensive. The advance directive for healthcare helps you to avoid that. So you're going to make a clear statement about what your wishes are with respect to end-of-life treatment, and you're going to say, this is the person that I want to make decisions about it. So that's a very important document. The second healthcare document that's important is what's called a HIPAA release. HIPAA is the Health Insurance Portability and Accountability Act, and it is a privacy law that restricts the amount of information that medical providers can share with someone else about you. When you go to the doctor's office and they give you the clipboard, one of the pieces of paper on the clipboard is a HIPAA release. And it says something to the effect of, I authorize you to talk to the following people about my medical care, and you write down the names, and then you're going to sign and date that at the bottom. And that works really, really well if you are competent and conscious when you go into the doctor's office. However, if you're in a situation where you're maybe in a coma, maybe you've been in a car wreck and you're unconscious and you can't speak for yourself, you can't sign a HIPAA release, the hospital is not supposed to release any information about you to any third parties. So what we do is we prepare a HIPAA release for you in advance, and it spells out, these are the people that I want to be able to get information about my medical treatment. That way your family will be able to get information if something happens to you. We then take that document and the advance directive and we send a copy of them to a company called DocuBank. And what DocuBank does is they store a copy of those documents, and then they send our clients a card to carry in their wallet. It looks just like a credit card. This is my DocuBank card that I carry in my wallet, and your DocuBank card has a 1-800 number and a PIN number on the front of it. And if you go into the hospital or the doctor's office, you just give them the DocuBank card. They take that, they take the 1-800 number and the PIN number off of the front of it. They call DocuBank, and then they have your documents emailed into the hospital or the doctor's office. So that way you've got access to those medical directives and that HIPAA release anytime you need it. The next document that's important for a living trust estate plan is a will. Now, I told you that planning with a will might not be the best way to plan, and now I'm telling you, you gotta have a will even when you have a living trust. What? This is crazy. So this is what's called a pour-over will. Now remember, when you set up the living trust, you set up a bucket and you put all your assets into the bucket. But what if you forgot about something? Or what if you acquired an asset and you didn't have time to get it into the trust before something happened to you? So for example, you went on vacation, you loved the place, you and your wife decided to buy a condo. On the way back to the airport, you were in a car wreck, both of you died, you didn't get the condo put into the trust before you passed away. The way that we deal with an asset like that that's been left out of the trust is with a pour-over will. And unfortunately, that asset will still have to go through probate, but we're going to avoid probate with the bulk of your estate, with the bulk of your assets. It's just anything that's been left out, we'd have to deal with using the pour-over will and the probate process. Now, the other important document that we'll prepare for our clients is something called a personal property memorandum. And what that document does is it allows you to write down a list of personal property, so things in your house that you want somebody to have. So for example, you might have a piece of artwork that you want Aunt Sally to get if something happens to you. So you would write down on this personal property memorandum, beautiful Picasso, Aunt Sally. And your will and your trust will reference that personal property memorandum, and it will instruct the trustee to use that personal property memorandum to distribute those items of personal property. So a living trust, a great way to plan your estate. It avoids the issues that we see with will planning. We've talked about all the documents that you need as part of that living trust estate plan. If there's anything we can do to help you establish your own living trust estate plan, the ultimate gift, contact us and set up a discovery call to see how we might be able to help. I hope you enjoyed that video. If you did, then take a moment right now to subscribe by clicking below and turn on the bell notification so you get notified every time we post up a new video. Right now, we're posting 3 videos a week with lots of information about various estate planning topics, so you're going to want to make sure to stay on top of that. Click right over here to watch the next most relevant video about estate planning. Go watch it now.